Good afternoon, everyone. Welcome to our inaugural Employment Law Essentials workshop. Today's workshop is the first of 7 workshops that we intend to provide to you on a monthly basis through to November. And each will focus on the essential elements of employment law. You would think that with 7-hour-long modules that we would have the opportunity to provide quite some level of detail on specific issues. But the reality is that's not the case. Employment law in Australia is so expansive now that even over a course of 7 different workshops, there is so much to cover that you would only be providing some insights into them. But we will bravely press ahead, and we hope by the end of this course, you'll have a much better understanding of the broad sweep of employment law in this country and some of the details as well that are very relevant to you. Employment law in Australia is more complex than any other country in the world. How can I make that claim? Well, I start with the fact that we have 122 different awards. That is, no other countries even have awards, let alone that many of them. So one of our motivations for delivering these workshops is a recognition of the difficulties that this complexity poses for people in your position as you have to make decisions on the ground every day. And so we will look to provide you with some practical guidance as to how to address a whole range of situations as they arise. Now, one of the challenges with a course like this is that everyone has a different level of understanding of employment law. So some people may find this a little basic, and for other people it may be all a bit bewildering. So we've tried to pick a point which assumes that people haven't studied it in detail and are coming to it, are having to sort of wrestle with it on a bits and pieces basis, but want a better understanding of how it all fits together. The other aspect of what we're doing here is my team has invested thousands of hours over the last 5 years developing a portal, Help, which is an online employment law solution. And in these workshops from time to time, we'll be using that portal in the course of demonstrating to you how to respond to certain claims or certain applications or certain issues raised by your employees. So you'll get a good insight as to how relevant it is or would be within your business or organisation. Our workplace relations team here at Hickson's Hunt & Hunt Holman Webb has grown dramatically over the last year. We now have 4 employment partners and a further 8 dedicated employment and work health and safety lawyers. The partners in that team are myself, Alicia Matere, Robin Young and Joey Tass, and each of us have our own teams of employment lawyers. So we're working together now, but what it does do is it allows us to offer a much deeper and broader range of skills to businesses, to people like yourself, as you have to face the challenges of dealing with employees on an ongoing basis. For those of you who don't know me, my name is Warwick Ryan. I lead a team of 4 employment lawyers based out of Newcastle and Sydney offices. I've been working as an employment lawyer for 25 plus years. I have a master's in labour law from Sydney Uni, and several years ago I was asked by the business school at UNSW to put together an employment law course for their masters in HR, and I teach that program twice a year. Joining me and presenting the second part of our workshop today is Alex Brand. She is a senior associate in my team. She's got 7 years experience working as an employment lawyer She has been recognised by the in the legal community and singled out as a rising star across New South Wales lawyers. She's she's a Kiwi, which is kind of ironic because she's talking about awards today, and she didn't have to encounter them until she showed up in Australia. But she, notwithstanding that, she has a detailed understanding of them because we deal with them every day. Now, just in a very broad context, I go into some detail when I'm lecturing at uni, but I won't bore you with this. But the relationship between, when we're talking about employment law, we're talking about the relationship between those who want work to be done and those who want to work and be paid for it. And obviously, it's as old as settled human existence, stretching back 7,000 years. The first recorded instance of industrial action actually dates back nearly 3,000 years in Egypt. But the law in relation to this relationship here in Australia, the employment law that governs us now, it's really emerged from about 800 years of common law and legislation in the UK, stretching back to the 13th century. It's morphed as society has changed over those centuries. But even now, there's hints and whispers of a very different type of employment law, which was much more power-based, going back centuries. An example of that is the obligation of an employee to follow a lawful direction, which really is a hangover from the idea of the master-servant relationship, which was such a feature of employment law for so many centuries. So what defines the employment relationship now? Well, it's the Fair Work Act as part of a broader sweep of sources of law. And it makes it that's part of the complexity that goes with the process of employing people and identifying rights and obligations. You have legislation, as I said, awards, and alongside them enterprise agreements, which have very similar impact as awards. And then you have the employment contract, and then you have policies. Now, each of these provides its own form of obligation. The way in which each of these is created is very different. And the consequences of breaching each of these sources of employment law is quite distinct. Legislation and awards probably closer together, but they're different again from contract and different again from policies. So if an employee breaches an employment contract, that gives the employer certain rights, and which is different to the rights that the employer has if they breach policies. Now, we're going to look in detail next month at contracts and policies. But today, we're going to look at the Fair Work Act and awards. In July, we'll unpack some of the emerging rights that sit within the National Employment Standards and elsewhere. For example, like the right to disconnect. That's not a NES, but it's in the Act. The right to flexible working arrangements, the right to request permanent employment if you're a casual, and navigating the different types of parental leave that are now a feature of the Fair Work Act. So we'll explore them in July. In August, we'll look at the minefield of disciplining, terminating non-performing or poorly behaving employees. In September, we're going to look at how do you deal with injured workers within a workplace, whether they're working and you're worried that they should not be, or perhaps they've been off work for a long period of time, and how we navigate that. It's a really challenging area. October's workshop will feature we'll focus on restructures and redundancies, and then in November, we will analyse the overall question of how to protect your business from an employee who plans to take away the business or the clients for their benefit. But let's start with the Fair Work Act. It commenced in 2010. The significance of it cannot be understated, as it covers pretty much all employees in the country, except for state government employees in most states, and in many states, council employees. They are exceptions, but interestingly, even with many state government organisations, they have been set up, even though they're wholly owned subsidiaries of the New South Wales government, to be covered by the Fair Work Act. An example of that is Sydney Trains. The stated purpose of the Act is set out quite clearly in that it, we might have a change of slide, Alex. I missed that one. You'll pardon me. It's set out to balance the competing interests of employees and employers. I'll keep my own counsel as to whether I feel it achieves that balance or whether it rewards one or the other. But as someone who I act for both sides, predominantly employers, and I think that probably employees get a fair go these days under the Fair Work Act. By way of scope, the Fair Work Act has 800 sections. So for today's purposes, in about 15 minutes, it's going to be tricky for me to go into any depth. But the purpose is to give you a sense of what's in there. And as I said, we'll circle back and address many of these more individual rights and obligations in later sessions. Before telling you what the Fair Work Act does, I'll quickly speak to what it doesn't cover and what remains within the scope of either states or other government legislation. Superannuation is covered by, it remains a Commonwealth matter, and it's referred to within the NES because there's an obligation, for example, to make payments of your responsibilities as an employer under the Fair Work Act. But the details of and the obligations that you are to meet in that regard are set out within the scope of the ATO or the various superannuation legislation, because there's about 3 or 4 different pieces of superannuation legislation. Perhaps one relevant ruling when you're dealing with superannuation is one known as SGR, that's S for Sam, G for Gary, R for Roger, 20092. And what it does, it sets out what qualifies as ordinary time earnings and what doesn't. And that's relevant. So the sort of questions we get as employment lawyers are, do I have to pay superannuation on a lump sum payment of annual leave when an employee is terminated? And another question we often get is, well, we sometimes get, is do I have to pay superannuation on annual leave loading as against annual leave? So they are 2 matters which are addressed within that ruling. So it's a really useful ruling, and I encourage you to look at it if you have to face those issues. Workers' compensation, that's obviously a whole area, and that's becoming much more relevant, but for another day with changes to the Workers' Compensation Act. Work health and safety remains a state-based obligations in New South Wales under the Work Health and Safety Act. Other areas of child labour, long service leave, workplace surveillance, jury service and discrimination, and also training arrangements, all of them sit outside and often alongside the Fair Work Act. Actually, the Fair Work Act now deals with sexual harassment, for example, which also sits within discrimination. So one of the difficulties, I guess, and you'll see this over the, if you are available to look at the different modules, is the way in which different areas of employment law are now starting to speak about issues that weren't really within their realm and are actually clearly within the realm of another regulatory body. So, for example, work health and safety issues around psychosocial injury now fall within work health and safety, workers' compensation, the Fair Work Act, and arguably even in discrimination. So that's a really complicating factor in all of this. But getting back to the issue of the Fair Work Act, so that's the matters there. So what's in the Fair Work Act? The Act is, the architecture of the Act is, and as I said, it's 800 sections, so it's, you know, it's a mouthful. The early part of it has some definitions, and we're going to look at some key definitions very quickly. It then goes on to look at terms and conditions. So, for example, it looks at the National Employment Standards, and we'll talk a bit about the National Employment Standards. It looks at awards, and of course, Alex is going to talk about awards and enterprise agreements and how they relate to one another, which outranks the other, as it were. And the little, you know, the hint is the National Employment Standards are the trump card, and they dominate the field. But of course, the awards and enterprise agreements are very significant in determining the rights of employees, because they go into a lot more detail and they're often tailored to the industry or the type of job relevant to the employee. The Fair Work Act then goes on to set out what national employment standards are. These are standards that cannot be diluted. So, for example, you cannot have a full-time employee in this country who accrues less than 4 weeks annual leave. And likewise, with personal leave, you cannot have a full-time employee who's accruing less than 2 weeks personal leave, and so on. So the national employment standards are a fundamental term that has to be complied with within, depending on the particular status of employment that the in which you are engaging that worker, whether it's, for example, a part-time role or a full-time role, or indeed a casual employment. Now, there's then a range of definitions, and we might have a quick look at some of those definitions now that I think are relevant to you, because they come up in all businesses at some time. The first of them is the question of who is an employee and an employer. The second is the second is casual employment, and the third is base rate of pay as against full rate of pay and when they're applicable. And that's just a little bit tricky. And the last one we'll look at is service and continuous service. And of course, we just don't have the time to go into detail, but I'm just going to introduce you to them. So the first of these is probably the most foundational, which is the Fair Work Act applies, except there's some exceptions to do with general protections and a few other areas, but by and large, it applies simply to employees. So the question is, who's an employee and who's a contractor? Now, for a long time, the situation was that it was a bit of a vibe approach to this, which is you look at the relationship, how it applies in practice, and you make that determination. Along came the High Court about 4 years ago and turned that upside down and said, no, it's about the contract. The Fair Work Act, through the Labor government, has recently introduced a provision which deals this question of who is an employer and employer. And we are back to the situation where you look at how the relationship is playing itself out in practice. So it's the totality of it. And there'll be questions, obviously, that would whether or not someone has a website, someone has premises, whether they have vehicles with signage on it. How's the individual paid? They paid upon presentation of an invoice, or are they just paid a fixed term? Are they paid on achieving certain outcomes, or are they paid an hourly rate? Do they have the right to employ someone, or do they are they circumscribed in that right and they can't themselves employ anyone? These are all matters which go to determine that. Now, just to make it a little bit confusing, in fact, it's a very confusing area, because the definition of the extended definition of who's an employer and who's an employee for the purposes of payroll tax, workers' compensation, and superannuation are different from the definition under the Fair Work Act. And in fact, they are different from one another. So you have no less than 4 different definitions as to who can fall within the scope of each of those pieces of legislation: the Fair Work Act, payroll tax, workers' comp, and superannuation. It does not make it easy. So we spend a lot of time giving advice in that space. So the next relevant section that definition is casual employment. Again, that's one that's been mapped out by within this legislation. It's a reasonably recent introduction, the definition, and it looks at issues such as the reasonable expectation of ongoing work, the right of the individual to refuse work or accept work as they choose. There are some features there, and they're mapped out now specifically within the Fair Work Act. The next definition that we'll look at is this question of service. So there's a couple of issues with service, and they're dealt with in the Fair Work Act specifically. Service is relevant across a range of issues. So it's obviously relevant to calculate annual, personal, and parental entitlement to parental leave. Also for the purposes of redundancy, so what you're entitled to there, and whether in fact you're entitled to make an unfair dismissal claim. They're just some of the circumstances where working out service is important. So there's a provision under the Fair Work Act which deals specifically whether or not only whether service comes to an end, but whether or not you can have service which may stop, but it continues on once the person resumes a role. So, for example, if someone is on unpaid leave, then there is the service stops. You don't calculate it for that period, but then again, it resumes at the end of that period, but it resumes. Whilst if someone obviously resigns from a job, and that can arise from time to time, that it can be a bit unclear if someone just disappears overseas, for example. In those circumstances, when they come back, then you've got a situation where it was deemed to have broken and you don't have service. So that's another definition that is worth attending to. And the final definition is 2 definitions: base rate of pay and full rate of pay. One of them just includes the basic hourly rate up to 38 hours. The other includes a whole bunch of other factors that may be part of their pay. And they are payable in different circumstances. So that is, for example, they are payable, base rate of pay applies to annual leave, personal leave, and redundancy, whilst full rate of pay applies to notice. That's pretty confusing when you're having to pay someone out to clarify that you've got different rates of pay that are applicable for those calculations. I'll keep moving along lest we run out of time. So I'm just going to quickly look at, so the National Employment Standards, they identify, as I've said, criteria which apply to employment which you cannot contract out of. We're going to come back and look at these a bit later on in future modules, but these are important because if you get them wrong, then it can be very costly. So these are the foundational obligations which cannot be avoided. And so we move on to this question of, it raises that question of why compliance is important. Now, Alex will talk a bit more about that when she's talking about awards, but the punitive section of the Fair Work Act, which is the compliance section, known as civil remedies provisions, that sits towards the end, around about the mid-500s of the Fair Work Act. And the penalties now are very steep where where a business is found non-compliant, and it stretches into, in many cases, millions of dollars, and certainly tens and if not hundreds of thousands of dollars penalties. One of the reasons why there's so much activity in this area is that claimants can ask that those penalties not go to the state, but be paid to them. So that's a sense of why compliance and attending to having understanding of the Fair Work Act and abiding by it is just so important for employers. So the final slides, before I hand over and we talk about awards, Alex, we're going to look quickly at, I'm going to talk to you quickly about, introduce you to the HELP program. This is just a snippet of how we comply with, how it helps employers comply with the Fair Work Act. For example, under the Fair Work Act, and coming out of a case that went, I think, all the way through to the High Court, certainly full federal court, to do with public holidays and the right of an employer to direct people to work on a public holiday. So now what we've done is we've included in one of our modules, for example, this facility to enable you to avoid any problems when you're requesting people to work on public holidays. So we might just play this quick video to show you how the module works in achieving compliance.
The Help Employee Conditions Letter Generator helps you manage changes to employee conditions, including preparing a letter asking an employee to work on a public holiday. After confirming the public holiday dates, the hint icon helps you record the reason why you require the employee to work on this date. After confirming the hours to be worked, the next hint provides more context, explaining how entitlements to penalty rates may apply. Final details are then recorded, helping to fill out the letter. On the left-hand side, you'll notice you can also start again if you need, save your progress, and if you select Download Record, Help will generate an Excel spreadsheet of the questions and answers. Help provides one final guardrail, ensuring employees understand that they must ask, not direct, employees to work on a public holiday, and with plenty of notice. Once complete, you simply download the tailored letter and can edit it immediately in Word. This compliant letter requests that an employee work on a public holiday, explains the operational need for the request, and gives the opportunity to an employee to provide reasons if they are unavailable.
So that's an example of how our portal helps you stay within the lines when it comes to dealing with obligations under the Fair Work Act. Okay, so I'm going to run through very quickly the last few slides. The Fair Work Act sets out your obligations as an employer, not just how and when you're to make payments, but also how you maintain employment records and also obviously the question of pay slips. Now, this has become a really relevant issue as a result of a very significant decision last year to do with Coles and Woolworths, which is they're still working through, and I think it's looking at costing them about $500 million. And it turned on a very small, on a particular interpretation under the NES, under the, pardon me, in relation to the maintenance of pay records. And it's had huge implications for employers. So the Fair Work addresses and sets a minima for employers in how they both pay staff and they record those details and in fact notify them. The next matter that we'll quickly address is this question of termination. Alex, sorry, we'll talk about termination later on and how you terminate the mechanics and what have you, employment of staff. But under the NES, there's obviously obligations. There's an obligation in relation to the payment of notice of when you and the fact that you can ask the employee to work out that notice, or indeed you can terminate them on the day but pay them out. But it also has certain requirements regarding the issuing of a notice in writing in relation to that termination. Now, there's some questions around when you've got to pay staff, and the awards deals, some awards actually specify that, but there's a recent ruling which has come out and said that you have to pay departing staff their NES obligations, NES entitlements on the day of termination, which has made it a difficult process for many employers whose payroll systems are a little bit are not as fluid as they should be. Okay, Alex, we might zip through the last couple to allow you some time to talk about modern awards. Okay, I'll just very quickly, there's a concept of shutdown that's available now under awards. So there's a mechanism, and I think Alex will talk about that. But the stand down right under the Fair Work Act, the Fair Work Act allows employers to stand employees down without pay in certain circumstances. They're limited circumstances. Obviously, it arose during COVID when the government issued certain edicts saying that employers couldn't come to work in certain industries. So that was an example of it. It arises where there's machinery breakdown, industrial action. It was a question that arose if oil prices got to a certain point where businesses were going to lose work. Is that within the employer's control? So that was going to be a difficult issue. Thankfully, it hasn't got quite as perilous as we thought. But in certain circumstances, employers can turn staff. The Fair Work Act allows employers to stand staff down without even having to pay them. And so that's just a glimpse of the Fair Work Act. As I said, it covers basically all non-state government employees in this country, apart from a few council workers. And we'll circle back to it in future modules, and we'll address some of the specific rights. But I'll hand it over to you, Alex, to introduce people to the wonders of modern awards.
Awesome. Thanks, Warwick. For everyone attending, I just want to flag, we do have a Q&A button on the screen. It should be at the top of your screen. We have allocated some time at the end to do our best to answer your questions and try and get through all of them. However, if we don't have time, feel free to leave a comment and we can come back to you, or send us an email, and hopefully you know how to contact us now. So I am going to spend some time now briefly explaining what modern awards are, how they are applied and interpreted, and some key causes within modern awards that employers can get themselves tripped up on. The starting point in understanding modern awards is to understand that they form part of the national employment standards to the extent that if an employer breaches a modern award, they are breaching a section of the Fair Work Act that falls within the NES, and the employer can be liable for a penalty. The unfortunate reality is that modern awards are not pieces of legislation that tend to have more love and attention given to them before they come into law. Instead, they are orders of the Fair Work Commission that are usually born out of a union or a series of unions banding together to advocate for a modern award for a particular industry or occupation. So what this means is that the modern awards we work with all the time have some clauses within them that are not brilliantly drafted. And there is often not a clear definition for some key terms within modern awards that leaves open the opportunity for disputes. What we've got on the screen here is some of the modern award objectives that are set by the Fair Work Act. Basically, a modern award is intended to be a raising of an employee's terms and conditions of employment that are otherwise afforded to them through the NES and the Fair Work Act. Like the Fair Work Act, where there is a dispute about how a modern award should be interpreted and the meaning of the clause is ambiguous, so it's not clear what is meant by the clause, the Fair Work Commission and the courts will almost always interpret the clause in favour of the employee. It's not the term beneficial legislation is not quite the right word, but it's of the same flavour. So unfortunately, the interpretation of modern awards is another example of why being an employer in the current day and age can be really challenging. Now, Warwick has briefly touched on this about why compliance is important, and we've listed some factors on the screen there. Warwick spoke about the penalties, which continue to increase, particularly where there's evidence of intention, so where an employer in some way intentionally breached a modern award. There are other reasons why an employer would want to comply with a modern award, and at a very practical level, one of those reasons is that how you manage an employee that's covered by a modern award can be different in many ways to how you manage an employee that isn't covered by a modern award. So the prime example is that if you're going through a restructure, which in the award is called, quote, major change, there is an obligation to consult with employees that are covered by modern awards in quite a specific way, and there's no such obligation for an employee that is not covered by a modern award. Whether you do or don't follow that process could then flow through to an alleged breach of the modern awards, alleged breach of the Fair Work Act, and potentially give that employee a right to bring an unfair dismissal claim. There is a two-tiered approach to determining whether an employee's role is covered by a modern award. So the first step is to go through the coverage clause of the award and determine if that award covers the employer or the employee or both. And then you go to what's called the classification section to determine if the employee's role is contemplated by one of those classifications. So it could be that there's a coverage clause that at first glance looks like it applies to the employer or the employee, but when you get to the classifications, that employee's role is not there. So in that case, what we would do if we're assessing modern award coverage, assuming we've ruled out every other modern award that we think is relevant, then we're kind of forced to go to the miscellaneous award, or as Warwick calls it, the MISOs award, and see whether that award would apply. It's basically a catch-all award that scoops up employees that would otherwise be covered by modern awards, but perhaps the awards haven't got there yet to contemplate their role. Then if that award doesn't apply, we can potentially get to a point where that employee's role is not award covered. Now, most commonly, employees at a mid to low level managerial role and below can be covered by a modern award, and managers at a senior executive level are not covered by a modern award. But it's not always safe to make that assumption. So there's some awards like the Registered and Licensed Clubs Award and the SHADS Award that cover almost all employees in the workplace, even all the way up to a Chief Executive Officer level. It's important to note that an employee's level of salary is not relevant to whether that employee's role is covered by a modern award or not. That might become relevant down the line if that employee brought a wage arrears claim, but it's not relevant to that threshold question. So there are two types of modern awards. There's industry awards that apply to employers and employees working within a specific sector or industry. A prime example would be the Building and Construction General On-Site Award. And then you have occupational awards, which can cover specific employees regardless of the industry that they're in. So one of the most common awards that we find ourselves looking at is the Clerks Award, which basically covers your clerical staff, bookkeepers, receptionists, people working in call centres. It could be that in a workplace, no other employees are covered by an award except those under the Clerks Award. I'll just briefly go through an example here. So we've got an employer who runs a business selling EAP software that they design in-house. So they also have another part of their business offering counselling and psychology services to the workplace, and they have a team of clerical administrative staff that support the business. So in this case, there could be multiple awards that apply to their workplace to different employees. What we've got on the screen here is the Professional Employees Award. So that could cover potentially the people sitting in designing the software that underpins that EAP software that they are selling, except for managers who aren't covered by that award. The counsellors and psychologists within that workplace would be covered by the Health Services Award, which makes a specific provision for those roles. And also employees working in clerical roles can also be covered by that award. Finally, we've got a mention here of the Miscellaneous Award. Modern awards can be slow to evolve and don't often contemplate all types of roles that employers are hiring and that are hiring these days, particularly in the tech space. So there could be some roles within the organisation at that lower level below management that are also covered by the Miscellaneous Award. So taking that all into account, you can understand the headache for anyone working in payroll and trying to work out everyone's entitlements. What we've got on the screen here are the types of entitlements that a modern award can and usually does cover that are not otherwise provided for in the National Employment Standards, so for non-award covered roles. To name a few, you have entitlements like receiving penalty rates for working nights, weekends, or public holidays. You have overtime and allowances for things like travel and meals. You have specific requirements for how your contract needs to be drafted to agree to hours of work for part-time employees and ways of changing the part-time employees' hours of work if they need to be varied over time. So that particular provision in awards can be really prescriptive, and it's often one of those clauses that we see employers getting caught out on, particularly where they're using pro forma contracts that don't contemplate what the award requires. So just to give you an example, under the Clerks Award, and this is a pretty classic clause, you have to agree in writing with a part-time employee about the number of hours they work each day, the days of the week in which the employee works, and the times at which the employee will start and finish work each day. And under that award, to change those hours, you have to agree in writing with the employee, which doesn't really contemplate how part-time work happens in practice, where sometimes someone's sick or for whatever reason there's an uplift in work for that week where you need that part-time employee to work a few extra hours, and you pop by their desk and ask if they're available, or give them a call and ask if they're available to work those extra hours. The way the award contemplates this, you'd actually have to agree in writing with the employee about that. You've also got obligations of consultation when you make major change, which is what I referenced before about the obligations when you're going through a restructure. You have specific rules about giving notice of a temporary shutdown when you want your employees to take annual leave, which is usually relevant over Christmas time for most businesses. And I've got a video to show you just after this about how the help portal can help you manage that process. Awards often prescribe when pay is due. So whilst the Fair Work Act allows for pay cycles to be up to monthly, except when you're giving or paying them out entitlements on termination, some awards will prescribe that pay has to be due weekly or fortnightly. So you need to do that comparison with your award to make sure that your set pay cycles within your workplace aren't going to fall foul of that. You will see that we have written unfair dismissal down on the bottom right there. This entitlement isn't written into modern awards, it's actually written into the Fair Work Act. Essentially, you can have an employee who is paid above the high income threshold, which is 183,100 gross, excluding super, so would not otherwise be entitled to bring an unfair dismissal claim. But if they're covered by an award or an enterprise agreement, they do have an entitlement to bring an unfair dismissal claim. So for most employers, unfair dismissal can be the least of their worries because the financial remedies are quite low in that jurisdiction compared to other claims an employee can bring. However, one remedy an employee can seek through unfair dismissal is reinstatement. And if you've terminated a problematic employee, the threat of an employee being reinstated can be really problematic for some employers. So it's important to understand what rights and entitlements an employee has so you don't get caught out. On the next screen, I am going to show you a brief video of our help portal and how that can step you through giving the notice required by most modern awards for a temporary shutdown.
The Help Employee Conditions letter generator helps you manage changes to employee conditions, including preparing a letter asking an employee to take annual leave during a temporary shutdown. At the outset, Help provides important guidance about awards and minimum notice requirements. After determining the shutdown dates, Help checks whether any public holidays fall within the period. The hint icon provides more context, explaining that employees are not required to use accrued annual leave on public holidays. The next hint also helps us record our reasons for the shutdown. Help then accounts for when employees don't have enough accrued annual leave. We can select available alternatives to offer, like annual leave in advance and working during the shutdown. Final details are recorded, and once complete, we simply download our tailored letter and can edit it immediately in Word. On the left, you can also restart, save your progress, and if you select Download Record, Help will generate an Excel spreadsheet of the questions and answers. This compliant letter gives employees clear notice, explains how annual leave and public holidays will be treated, and sets out available options where accrued leave is insufficient. The Help Employee
Righto, so final slide here. One way that employers trip up with modern award compliance is by too heavily relying on their contracts for safety and assuming that because an employee has agreed to be paid certain entitlements under the contract, there was no recourse for extra entitlements under the award. What's an important and key takeaway for you to have leaving this seminar is that award entitlements apply regardless of whether they're mentioned in the contract and even if they are reduced in the contract. So a prime example of how employers are getting tripped up on this comes out of a federal court case that was published last year involving the Fair Work Ombudsman and Coles and Woolworths. So that's a case that we will continue to revisit throughout these seminars because of its wide-ranging impacts for employers. But in this case, what's important to note is that, or what fell out of the case, is that a well-drafted all monies clause or offset clause in your contract, which would otherwise function to allow you to offset extra entitlements paid one week against money owed the following week, perhaps if they're covered by a modern award, you can't do that anymore. So, for example, a full-time salaried employee may be paid fortnightly. We'll assume they're covered by an award because that's when this is relevant. And they may work 90 hours over that fortnight, so 14 hours above their contracted hours and above the ordinary hours under an award. Then the next fortnight, they would work 70 hours, but still get paid their usual salary. No one makes fuss about it, usually, because the employee worked higher hours the previous fortnight, and then there's kind of a forgiving of it in the following week. They say, you know what, don't worry, you worked really hard last fortnight, you can go home early. Now, the federal court is saying that in that fortnight where they worked extra hours and overtime was due, that money has to be paid within that pay period, and you can't offset that by allowing the employee to, for example, work less hours in the following pay period. So this is why it's so important for employers and employees. Sorry, for employers that employ individuals who are covered by a bond award to accurately record all hours that employee is working, including for salaried employees, so that you can track when extra payments are due on that salary to top them up to whatever they are owed. So for some employers, this may require quite a dramatic change to how they monitor a salaried employee's hours of work, particularly where the employer may be running a high trust model and basically just trusting the employee to get the job done, or where that employee works partially or fully remote. And so it can be really hard to know what they're up to and when they're working. Now we've got a few minutes for questions. Before we answer some of your questions, we've got some questions to pose to you for you to go away and have a think about. So those questions are, when was the last time you considered your organisation's award coverage? Have you considered your employees' classifications under the awards recently? Have they moved up a pay level? Have they changed roles so that their current modern award assessment is not correct? And when was the last time you audited your employee record keeping? Noting that that federal court case last year really changed the game when it comes to record keeping obligations. All right, we've got about 5 minutes for questions.
Okay, so we've got some questions, Alex, and I might throw one at you from Ian Ed. He asked the question of that his organisation he sees as not falling under any particular industry award. So what's the best way of ascertaining the relevant award for the various staff within the organisation?
Okay. If you don't think you fall under an industry award, and we'll assume that's the case, then the question is whether occupational awards would apply to people within your workplace. So the most obvious starting point would be the Clerk's Award. Do you have employees performing clerical duties, bookkeeping, answering your phones? And if there's no industry award that applies, that's a pretty obvious kind of low-hanging fruit award that could apply in your workplace. And generally the way that we do that, there's lots of different ways to assess your modern award coverage, and unfortunately there's no kind of silver bullet, but sometimes we start with a sample of employees doing different roles within the organisation, generally at that lower level. We have a look at their roles, we see whether they fit into anything, and then if the employer decides they need to escalate or broaden their assessment, then we work with them to broaden that assessment to take into account other roles in the workplace.
What's Alex? What's the test that's applied? Is it major and substantial from memory?
Yeah, major and substantial. Yeah. So if there's potentially 2 awards that could apply to an employee, and you're not sure which one applies, then the question is, what does the employee basically spend the major and substantial part of their doing, and what were they employed to do? And that can help you assess which category that employee falls into.
This is a nice segue into a real bugbear of mine, or really a strong theme, which we'll address next week when we look at the contract. But it makes job descriptions so important, because job descriptions have many functions, but one of them is to enable you to work out what your award coverage is. And can I encourage you, when you're drafting job descriptions, and if there is an award that's applicable, have a look at the different categories and maybe embrace some of the language from that. It makes it so much easier to defend a claim later on that maybe you were paying someone as a level 2 instead of a level 3, or they should have been in a different role than the one that you were paying them in. So yeah, that's a really fundamental part of that. Another question, what about if someone comes to a business and says, listen, and you want to employ, the business wants to employ them, and they say, no, I want to be a contractor. Is there that, if the worker decides they want to be a contractor, is that enough? Does that get them off the hook?
Yeah, well, before the Fair Work Act was amended recently to include this test assessing the totality of the working relationship, if you wrap that up in a nice contract and you had both agreed that they were going to be an independent contractor, then that could be a way to get out of it. Now, unfortunately, the way that the law has developed, it may be all well and good that they start out as a contractor, and maybe that is the case, that the way that the contract is performed at the start is of an independent contractor and a principal. But over time, if that evolves to effectively be an employment relationship, what they intended at the start is actually not going to be relevant anymore.
Yeah, perhaps we can sum it up by saying, you know, if it's big and grey with big ears and a trunk, it's probably an elephant, regardless if it thinks it's a zebra. So one way you might want to sidestep it is if you can convince the employee to incorporate, set up a little company, that can often be a way in which you can delineate it. Okay, so I've got a couple of other questions that have come in. Now, again, this question we see where there's duties spanning across a few different classifications in a modern award. Sorry, just circling back, this probably touches on the same issue, which is this question of the test is where you've got a couple of different categories. It's where the major and substantial nature of the duties they carry out as to how it marries up with the particular category. Is that essentially the test? Alex?
Yeah, yes, correct. Major and substantial is the key question there. What were they employed to do? What are they spending majority of their time doing? That's what you have to think about.
Okay, so there's so that's the questions we've had, and I think we are basically at time. We'll send out following up. We'll send out a copy of this presentation, and obviously, if you have any comments, we'll also send out a survey. We want to ensure that you get value and out of these presentations, and also if you've got any questions that arise, by all means, put them in an email to us, and if we can answer them in a general sense, we're happy to do that. So we will see you all on the next occasion in a month's time, and where we'll look at the role of contracts and policies in defining the employment relationship. Good afternoon.
Thanks, everyone.